The Supreme Court made a very important ruling in a trademark case related to Jack Daniels. If you are a business owner that likes to make products that are a parody of other products, or if you have your own product that someone is making a parody of, you're going to want to listen to this one. Jack Daniels sued a company called Bad Spaniels that made a chew toy for dogs that looked just like the Jack Daniels bottle with just a couple of changes, like instead of 100% alcohol, it said 100% poop. Jack Daniels sued, and a lower court actually threw out the case in support of Bad Spaniels. The lower court reasoned that it was just a parody, and the First Amendment gives this other company the right to make a product that is not exactly the same as the Jack Daniels product. The Supreme Court highly disagreed. They sent the case back to the lower court to make a determination on whether or not there was trademark infringement and a likelihood of confusion between the two products. So the Supreme Court didn't say that it was in fact trademark infringement. They just said that Jack Daniels has a right to have a trial to determine if it was trademark infringement. The Supreme Court reasoned that the First Amendment does not trump trademark rights. And while the dog toy was simply a parody of the Jack Daniels bottle, there may still be a chance for a likelihood of confusion. While Jack Daniels makes whiskey, it's not unheard of that they may make products for dogs, animals, clothes, t-shirts, and the like. And if customers of Jack Daniels would buy this Bad Spaniels product, maybe they're a Jack Daniels fan and they wanted their dogs to be able to have a chance to join in on the fun, that they would buy the product believing that it was an actual Jack Daniels product. Remember, trademarks are brand identifiers, and if your customers would go in and purchase a product because they believe that it's coming from your brand, that is trademark infringement. Now, Jack Daniels may still lose when the case goes back because a jury may determine that there's not a likelihood of confusion between a dog toy and whiskey. But the important takeaway here is that the Supreme Court has finally decided that the First Amendment and parody is not a defense throwing out a case for trademark infringement. So Nike's Just Do It? You can't make a dog toy that's called Just Poo It. Got a condom line? You can't call it Just Hugging It for Just Loving It, because there could be potential trademark infringement. This ruling could affect a lot of products, particularly apparel, where people simply take something that another brand has and kind of turns it into their own. So if you do that, be cautious. And if you don't already follow me, you should. I'm attorney LBJ. I'm an intellectual property attorney that likes to help small businesses build their brand. Watch my other videos, give me a like and a follow, and happy drinking.